Good morning. My name is Tammy Mitchell. I'm the Director of the Office of Energy System Planning and Performance at the New York State Department of Public Service. I have been designated to serve as the alternate representing the chair of the New York State Board on Electric Generation Siting and the Environment, or as it is also known, the Siting Board. I call this meeting of the Siting Board to order. Before moving to the agenda, I would like to introduce the alternates representing the permanent members of the Siting Board. When I call your name, please confirm that you are present. Louis Alexander, alternate representing the Commissioner of the New York State Department of Environmental Conservation.
Present.
Kevin Malone, alternate representing the Commissioner of the New York State Department of Health.
Present.
Vincent Ravishir, alternate representing the Commissioner of the New York State Department of Economic Development.
Present.
And John Williams, alternate representing the Chair of the New York State Energy Research and Development Authority.
Present.
Thank you. Secretary Phillips, are there any changes to the agenda?
There are no changes to the agenda. I do want to note, however, that while we have one case that is before the Siting Board, we have three separate decisions, two relating to an amendment petition and one relating to a road use agreement.
Thank you. I call case 17-F-0282, application of Alle-Catt Wind Energy, LLC, for a certificate of environmental compatibility and public need pursuant to Article 10 for a proposed wind energy project located in Allegany, Cattaraugus, and Wyoming counties, New York, in the towns of Arcade, Centerville, Farmersville, Freedom, and Rushford. As noted, there will be three presentations related to this case. The first two presentations pertain to the amendment petition that was filed in this proceeding on January 30th, 2023, and supplemented on February 28th, March 9th, June 5th, and June 12th, 2023. The third concerns the road use agreement petition that was filed on May 7th, 2021, and supplemented on March 15th, 2023. They will be presented in order by Tara Kersey, Administrative Law Judge, Norina Chaudhry, Assistant Counsel, and Jesse Shaw, Assistant Counsel, each from the Department of Public Service. The board will listen to all three presentations and will then ask any questions or make any comments that the members may have. Dakin Leacakes, Chief Administrative Law Judge, Department of Public Service, Heather Benke, Managing Attorney, Department of Public Service, Jason Zaire, Chief of Environmental Certification and Compliance, Office of Energy System Planning and Performance, Department of Public Service, and Robert Rosenthal, General Counsel, are available for questions. Judge Kersey, please begin.
Thank you, and good morning, Chair Designee Mitchell and members of the board. For the first of these Alle-Catt items, before you is an order that, if adopted, will grant a request for the Siting Board to waive the substantive requirements of two local laws. Granting these waivers will allow the Siting Board to then consider Alle-Catt's petitions for amendments to the Siting Board's June 3rd, 2020 order, in which the board granted Alle-Catt a conditional certificate of environmental compatibility and public need. The Siting Board's June 2020 certificate approved the construction and operation of a wind energy project consisting of up to 116 utility-scale wind turbines, with a capacity of up to 340 megawatts to be located in the towns of Arcade, Centerville, Rushford, Farmersville, and Freedom in the counties of Allegany, Cattaraugus, and Wyoming. In January 2023, Alle-Catt requested approval, among other things, to install fewer wind turbines with the physical dimensions and properties of the turbines remaining the same. Alle-Catt's requested amendments will allow it to revise the location of a number of turbines and to construct 11 additional structures that were not part of its initial project proposal and so not included in its existing certificate. Notably, under local laws adopted after a hearing was held on the original application, Alle-Catt's proposed additional structures qualify as accessory structures. Under the most recently adopted local laws, the setbacks from property lines and existing structures that were applicable to the Siting Board's June 2020 certificate have been changed and would prevent the Siting Board's grant of the amendments with respect to the additional structures if Alle-Catt is not granted a waiver from these requirements. In support of its waiver request, Alle-Catt has argued that the certificated project with the additional structures would help the state achieve its clean energy goals under the Climate Leadership and Community Protection Act, State Energy Plan, and the Public Service Commission's Clean Energy Standard Orders. Alle-Catt also asserts that installation of the proposed additional structures collectively reduces environmental impacts compared to the certificated project. Norina Chaudhry will present a more complete overview of Alle-Catt's requested amendments and the Department of Public Services recommendations on whether it should grant those amendments. The specific request to construct 11 additional structures includes a 100-foot microwave tower at the facility collection substation to provide redundant communication capability between the certificated project, the Delavan substation, and Alle-Catt's point of interconnection. 3 aircraft detection lighting systems, referred to herein as ADLS structures, to improve aircraft safety while minimizing nighttime lighting impacts, and 7 identiflight towers to detect the presence of bald eagles and provide automated curtailment capability for the identified turbines. The proposed placement of these additional structures created a conflict with 2 specific local laws that address setback requirements of such additional structures. Article 3, Section 17D of Town of Farmersville Local Law 4 of 2020, and Article 3, Section 17D of Town of Freedom Local Law 2 of 2020, both require that any related infrastructure, electrical lines, access roads, and/or accessory structures of a wind energy facility be located a minimum of 2,000 feet from any residence or property line. As noted by Secretary Phillips in a July 6, 2023 letter to Alle-Catt, a local law waiver request requires a substantive finding. Under Article 10, the Siting Board may waive a local law after making a finding that the law is unreasonably burdensome in view of existing technology, or a finding that such waiver is otherwise in the public interest. To make its determination on a waiver request, the Siting Board should consider the state of available technology, the nature and economics of reasonable alternatives, the environmental impacts of the project, the impact of construction and operation of related facilities, the consistency of the construction and operation of the facility with the energy policies and long-range energy planning objectives and strategies contained in the most recent state energy plan, and the impact on community character. Initially, Judge Lee Cakes and I required briefing on the issue as to which laws were applicable to the project and whether the record demonstrated an entitlement to the requested waiver. After receiving the parties' briefs, we determined that there remained an open question as to certain factual elements the board needs to consider and requested party affidavits to determine whether any factual dispute existed and ultimately whether Alle-Catt has demonstrated an entitlement to the requested waivers. Through Alle-Catt's witnesses, we concluded that there are no possible locations where any of the proposed additional structures can be sited and serve their intended functions while complying with the applicable local law's setback requirements. More specifically, a newly proposed microwave tower is intended to provide one of the 2 required redundant, independent, and dedicated means of communication between the project's operations and National Grid, owner of the Delavan substation, where Alle-Catt's transmission line will interconnect with the state's electric grid. Data carried over these communication media will inform the operators of the project and those of the grid of the status and condition of the meters, breakers, and interconnection line at the collection substation and point of interconnection switchyard. This secondary form of redundant communication to be supplied by the microwave tower is required to comply with reliability rules enforced by National Grid and the New York Independent System Operator. The tower's proposed location was selected to avoid interference with existing microwave communication paths, while accounting for, among other things, the location and elevation of the substation and point of interconnection. We concluded that Alle-Catt adequately demonstrated that the proposed location is necessary, despite requiring a waiver of local laws, as the microwave tower must be sited as part of the collection substation located in the town of Freedom. While Alle-Catt noted an alternative means for providing the requisite dedicated independent line exists, that alternative would involve the installation of a fiber optic line via the excavation of a trench over 10 miles long between the collection substation and point of interconnection switchyard, which would increase the environmental impacts associated with providing a required method of redundant communication. As to Alle-Catt's proposed ADLS radar towers, its witnesses noted that the 3 proposed towers were best located in the towns of Centerville, Freedom, and Farmersville, as they are intended to reduce nighttime light pollution of the project. Notably, the inclusion of such towers was considered by the Siting Board and are being proposed to comply with Certificate Condition 40C of the June 2020 certificate. These towers address Federal Aviation Administration rules that require certain structures to contain warning lights so that those structures are visible to aircraft pilots. Alle-Catt's evidence indicates that the ADLS towers' proposed locations were selected due to the constraints of their technological capability concerning their view of the airspace surrounding the wind turbines and their proximity to the turbines they are affecting, which are predominantly located in the towns of Centerville, Freedom, and Farmersville. Finally, Alle-Catt's witnesses explained that its proposed Identiflight towers are intended to reduce and or eliminate the hazard posed by 16 project turbines located within 2 miles of a specific bald eagle's nest in the town of Freedom. Identiflight utilizes high-precision optical technology to detect and identify protected avian species that fly within a 1-kilometer hemisphere around each tower, and is intended to provide automatic curtailment capability for the identified turbines. The evidence indicates that the location for the 7 Identiflight structures is limited, and that the specific locations at issue were selected by considering the locations of both the bald eagle's nest at issue and the turbines with the greatest potential on the bald eagle's activity in the town of Freedom, as well as the coverage radius of the Identiflight towers and the technologic necessity that each tower is within the visible range of another neighboring tower to ensure effective coverage. Such structures will result in further minimization of impacts already allowed in the Siting Board's June 2020 certificate order. We recommend that the Siting Board allow the requested waivers for the 11 proposed accessory structures of the 2,000-foot setback restrictions set forth in Article 3, Section 17D of the Town of Farmersville Local Law 4 of 2020, and Article 3, Section 17D of the Town of Freedom Local Law 2 of 2020. Based upon the evidence, the restrictions are unreasonably burdensome in light of existing technology, and the additional structures will allow for project construction and operation, furthering New York's energy planning goals. In making this recommendation, we note that the record indicates that while some participating parties, notably the Coalition of Concerned Citizens and later Cattaraugus County, filed briefs taking issue with the waiver requests, neither the Town of Freedom nor of Farmersville submitted any opposition to Alle-Catt's request for a waiver of their own local laws. This concludes my presentation.
Thank you, Judge Kersey. Ms. Chaudhry, will you please begin your presentation?
Good morning, Chair Designee Mitchell and members of the Board. Before you today is a draft order granting a petition for amendment of the Board's June 3rd, 2020 order granting a certificate of environmental compatibility and public need with conditions to Alle-Catt Wind Energy, LLC. As explained by Judge Kersey, on January 30th, 2023, Alle-Catt Wind filed a petition for amendment seeking approval to 1. Change the facility to reduce the number of wind turbine generators, 2. Shift the location of 7 turbines and associated access roads and collection line corridors, 3. Add a 100-foot microwave tower at the collection substation, 3. Aircraft detection lighting systems, or ADLS, and 7 98.5-foot tall Identiflight towers, and 4. Change Certificate Condition 9 to replace 5 years with 10 years. The Secretary to the Siting Board consulted with staff of the Department of Public Service, the Department of Environmental Conservation, and the Department of Health before issuing an initial February 14, 2023 letter notifying Alle-Catt Wind that the amendment petition did not contain sufficient information to determine whether it constituted a revision or modification pursuant to 16 NYS Section 1000.16a. After Alle-Catt Wind submitted a series of supplemental filings to provide the additional information requested in the Secretary's letter, the Secretary to the Siting Board ultimately concluded that the proposed modifications would not result in a significant adverse increase to environmental impacts as compared to the certificated project. Therefore, the modifications did not constitute a revision that would require a hearing under the regulations. However, as just explained, Alle-Catt Wind's request for a waiver of local law required further process. Alle-Catt Wind explains that the modified facility will consist of 83 turbines without a change in generating capacity. 7 of those turbines and associated roads and collection line corridors will be shifted to accommodate landowner concerns, optimize site constructability, and to further minimize wetland and stream impacts. With respect to the additional accessory structures, Alle-Catt Wind explains that the proposed microwave tower will fulfill requirements under its interconnection agreement. The proposed ADLS will regulate turbine lighting when aircrafts are in the vicinity of the facility, and the Identiflight towers will monitor for and detect eagles in an effort to avoid collision risk. The draft order before you explains that the modifications involving both location shifts and the addition of accessory structures are not expected to result in a significant adverse increase to environmental impacts as compared to the certificated project. The Secretary's letter included a thorough review and addressed potential impacts of the proposed changes for the project related to noise and vibration, shadow flicker, cultural resources, terrestrial ecology and wetlands, threatened and endangered species, visual impacts, effects on communications, and electromagnetic fields. As summarized in the draft order before you, the proposed changes will not result in a significant adverse increase to environmental impacts as compared to the certificated project. With respect to Certificate Condition 9, regarding the certificate expiration, Alle-Catt Wind explains that it is asking the Siting Board to replace 5 years with 10 years to account for previous and possibly future litigation delays, time required to secure local road use agreements, turbines, and other long lead time equipment and supplies, and the time required to complete transmission system upgrades. The draft order explains that the request is administrative. While several commenters raised concerns about information on the facility's impacts becoming outdated, the draft order notes that the Siting Board has previously recognized that it is appropriate for a certificate to expire 10 years after issuance. However, the draft order emphasizes an expectation that the facility will commence commercial operation by 2030. Accordingly, the draft order before you approves the petition for amendment. This approval does not relieve Alle-Catt Wind of the need to comply with the terms, conditions, limitations, or modifications of the construction and operation of the facility authorized in the certificate. This concludes my presentation.
Thank you, Ms. Chaudhry. Ms. Shaw, will you please begin your presentation?
Good morning, Chair Designee Mitchell and members of the board. Before you today is a draft order granting a petition for relief pursuant to a condition of the Certificate of Environmental Compatibility and Public Need granted to Alle-Catt Wind Energy, LLC through the board's June 3, 2020 order. As explained, the project includes wind turbines located in the towns of Freedom and Farmersville in Cattaraugus County. The petition requests that the board relieve Alle-Catt from a requirement in Attachment A of the certificate order, which requires Alle-Catt to submit a road use agreement between Alle-Catt and the towns or counties the project is located in. Certificate Condition 4 allows the certificate holder to petition the board if it believes any action or determination from a state or local agency was unreasonably delayed or withheld. Under this condition, Alle-Catt requests that the board issue a determination that Cattaraugus County has unreasonably delayed entering into a road use agreement with Alle-Catt to allow it to use the roads and highways under control of the county for activities required for the construction, operations, and maintenance of the Alle-Catt Wind Energy Project. Further, the petition requests that the board authorize Alle-Catt to evaluate, modify, and use county-owned roads and highways subject to the terms of a draft road use agreement included with the petition. Alle-Catt first initiated negotiations of the road use agreement with Cattaraugus County in June of 2020. and they have subsequently met and exchanged multiple drafts of the document. However, the parties have failed to execute a road use agreement. Even after initial negotiations, Alle-Catt was not given the opportunity to present the road use agreement at the Cattaraugus County Board meeting for over 1 year. Based on the specific facts and history of negotiations between Alle-Catt and Cattaraugus County, the draft order before you determines that the county has caused unreasonable delay in failing to approve the road use agreement, as it is clear that a significant amount of time has passed since negotiations were initiated. Further, the draft order explains that continuing to cause delay of the project would be contrary to the purposes of Article 10 of the Public Service Law. Cattaraugus County and the Coalition of Concerned Citizens both oppose the petition and ask that the board deny Alle-Catt's request because granting the requested relief would constitute a revision of the certificate and would violate Article 9, Section 2C6 of the New York State Constitution, which gives local governments the authority to adopt laws for the use of its roads and highways, provided that the local law is not inconsistent with the general law. The draft order finds that relief sought by Alle-Catt is not a revision of the certificate because Certificate Condition 4 expressly offers the certificate holder relief when the board determines a local agency has caused unreasonable delay in an action required under the certificate order, which includes the action of entering into a road use agreement. The draft order also finds that issuing a determination that Cattaraugus County acted unreasonably and caused unreasonable delay in executing its road use agreement does not violate Article 9, Section 2C6 of the New York State Constitution. Article 10 of the Public Service Law is a general law under the state constitution with the exclusive authority to regulate the siting of electric generating facilities. Public Service Law, Article 10, Section 172 expressly preempts a locality from requiring approval, consent, or a permit issued by a county for the use of its roads and highways. Therefore, Cattaraugus County law, which requires a permit issued by the county for the use of its roads and highways, is preempted, and the board is not obligated to require a road use agreement between the two parties. The draft order before you determines that Cattaraugus County has acted unreasonably and caused unreasonable delay in failing to execute its road use agreement with Alle-Catt. Further, the order withdraws the authority delegated to Cattaraugus County to exercise control over its roads and highways with regards to the construction, operation, and maintenance of the Alle-Catt Wind Energy Project, and directs Alle-Catt to submit as a compliance filing plans for how it intends to use the roads and highways owned and operated by Cattaraugus County. This concludes my presentation.
Thank you, Ms. Shaw. I have no comments or questions on the items. Let me turn to my fellow board members for any comments or questions. Mr. Alexander.
Thank you, Madam Chair. First of all, I would like to thank the presenters for a very comprehensive review of the issues that are before us today. I do have a couple of comments and one question for you. First, regarding the local law waiver request, and this is simply a comment. In terms of these additional structures, I note also in reviewing the record the October 6th affidavit that was submitted on behalf of Alle-Catt. I thought very well set forth some of the rationale and importance of these additional structures, including but not limited to the ADLS and the Identiflight structures that are set forth. And I think the order well goes through and evaluates each of those in the context of the local law waivers. In terms of the order that deals with the amendment subject to conditions, and I believe this is well reflected in the order, but I just wanted to confirm it. Obviously, we often get issues relating to noise, vibration, as well as shadow flicker. And we've seen that in a number of our proceedings before the board. as I understand it, please correct me if I'm wrong, you know, as I read this order and the language that sets forth in terms of page 10, the original certificate requirements will be still in effect as to you know, the changes that are being considered here. Am I correct in that
That's
evaluation?
correct. This draft order will make no changes to the existing certificate conditions as they relate to noise and vibration and shadow flicker. Alle-Catt will still be required to comply with those requirements.
Okay, thank you. And then lastly, all I would say in terms of the road use agreement, I am sorry that the parties weren't able to work this out in terms of whatever disagreements or delay issues that they had, and it had to come, you know, to the board. But I think that the proposed order does set forth the necessary evaluation that would certainly lead me to support this order when the vote is taken. But again, thanks to all for the presentation. And Madam Chair, my remarks are completed. I yield back my time.
Thank you, Mr. Alexander. Mr. Malone?
Yes, thank you for the presentations. I have no comments or questions.
Mr. Ravishir?
No questions or comments. Thank you.
Mr. Williams?
And no comments or questions.
I will now call for a vote. My own vote is in favor of the recommendations as described. Mr. Alexander, how do you vote?
I vote in favor.
Mr. Malone?
I vote in favor.
Mr. Ravishir?
In favor.
Mr. Williams?
In favor.
The three orders are approved and the recommendations contained therein are adopted. Secretary Phillips, is there anything further to come before us today?
There's nothing further today.
Thank you, and we are adjourned.